Testing 1 2, testing 1 2. Testing 1 2, testing 1 2. Beautiful. All right, everybody. Thank you for checking in. Well, today I got a little story for you. And in that, I have a little lesson. So, actually, yeah, that was actually pretty good. Now, I go to Burlington, as you see in the title. My day at Burlington and what you can do whenever something happens to you. Now, it's kind of, it's not, let me, it's not a huge thing because it was remedied kind of quickly. However, I go to Burlington's, I want to say probably once every 2 weeks. Let's call it that because I get stuff that's kind of get some good quality stuff for the low. And they also have these seaweed chips that I eat. And everywhere else that have them like Sprouts or Target, they're generally 11, $12. Burlington's will have the exact same seaweed chips for $4. So I go to Burlington to grab the $4. Well, anyway, I go in and as soon as I walk in, young lady stops me. And she goes, "Hey, you can't bring your bag in. You can't wear your bag." And I look at her kind of crazy because literally I actually had went in there, I want to say the day before because I wanted to make sure they had the chips because I know they go kind of fast. And I didn't grab any. So when I went there literally specifically for that. Had my bag with me because generally whenever I'm out or walking around, I'll have my bag on me. Not because of anything, but a lot of times I'll sit down with my iPad or my phone, or hell, there's a couple parks around the area where I live at, and I'll post up and just eat or watch TV or something, or watch the iPad or something. But again, have my bag with me. Well, this young lady took it upon herself, for the most part, to tell me I couldn't come in there with the bag. So then I'm like, oh, kind of odd because I'm looking at three or four people with bags. So I'm like, hold on, you do realize that's discrimination just off top because you're telling me I can't do it and I'm looking at four people with bags. So I asked her, what's different about my bag? Well, long story short, I asked for a manager. She goes over there. I pulled a Karen. Asked for a manager. Now, the reason why this story became intriguing is because the manager immediately she's looking at me odd because, again, she sees me in there at least once or twice a month. And she goes, yeah, she misspoke. Now, again, seemingly innocuous, not really a big deal. Because for me at the time, it was not as big a deal as I'm making it. But I thought about it. If she stopped me regarding a bag, she's done it previous because she was very comfortable telling me that I couldn't come in there with the bag. So I go in there and I actually finish shopping. I leave out and it actually made me kind of restless. So I was like, you know what? Let me just go through because I constantly tell you guys, if you condone the behavior, you're telling them they can keep doing this without punishment, so you become part of the problem. By not saying anything or escalating this, I was part of the problem because I was telling this young lady it was okay for her to do the things that she was doing. Now, so what happens if you're in that type of situation? Because again, most people will just go and just write out, I'm upset because of this, and it's not really an effect because, like I said, the manager that was on scene handled it immediately. But here's the take. I actually escalated this to basically I took the nuclear option for the most part that I spoke about a couple weeks ago. Whenever you're doing some type of either legal defense or legal setup. So I escalated it to Burlington's chief executive officer, which I know he's not going to read it. Their legal department. Now, why the legal department? Because what I'm doing is offering not a demand letter, but a formal legal complaint for discriminatory treatment, and I gave the specific location of the store and store number. Now, I give a date and a time in my complaint. Again, list the store, and then I give the story. I was stopped by a female security guard who informed me I could not enter with a bag on my shoulders. I immediately pointed out 3 to 4 others that were carrying bags. Yet, I alone was singled out and denied entry. When I questioned the guard what was the difference about my bag, I received no legitimate explanation. Now, you might ask, why am I reading this letter? Because I want you to understand where I went and why I went there. So, excuse me. Now, I felt left with no alternative but to conclude that I was targeted either because of my gender or because of my race or skin color. Again, it's not one of those because it's literally happenstance. At the time, I was the only black male there. And it was the easy. Now, I put in there, both are protected classes under Title II of the Civil Rights Act of 1964. I also threw in the federal code, 42 U.S.C. Section 2000A, which prohibit discrimination in places of public accommodation, including retail establishments. Why? Because again, this is a formal legal complaint, not a demand letter. There's literally a big difference in that. Now, here's where I separated to let them know I'm not taking legal action. I point out the store manager later admitted that the guard had misspoken. This admission is insufficient. I consider this incident to be a serious violation of federal civil rights, Texas statutory protections, and Burlington's duty of equal treatment to customers. Because this, for me, is part of their training. Because I looked it up. And you'll be surprised at what Burlington and other companies have online that's readily available. Not to mention, Burlington's is a publicly traded company. Now, I also put in federal civil rights violations, the Heart of Atlanta Motel v. United States, and this is a 1964 case. The United States Supreme Court held that business open to the public cannot engage in discriminatory practices based on race or protected categories. Burlington's, as a place of public accommodation, is bound by this principle. That's why I put that case there. Newman v. Piggy Park Enterprises, 1968. The court reaffirmed the denial of service based on race, even under a pretext of business reasons, is unlawful. Because again, Burlington's is a place of accommodation and is bound by this principle. Now, I'll go into Texas statutory case law. Texas Business and Commerce Code, Section 17.46. Deceptive Trade Practices Act. Understand that. Prohibits false, misleading, or discriminatory practices in trade and commerce. Discriminatory treatment of customers falls squarely within unfair and unlawful practices. This, again, something as simple as saying you can't come in here with a bag And there are several people that are there with bags. Because if you tell one person they can't come in with a bag, that means all bags are banned, not just one. And again, it becomes unfair and unlawful. United States v. De La Rosa, 1991. The Fifth Circuit confirmed heightened scrutiny applies when policies disappropriately impact a protected class. So again, her being comfortable telling me that's not like any of the other people that was carrying the same bag was disappropriately impacting me and those that look like me, whether they were male or whether they had dark skin. Because everybody else was not male and was not dark skinned. So understand those happen. R. V. Garcia, 2006, adopted in principle by Texas federal courts, reinforces that corporations can be held civilly liable for discriminatory actions by employees acting under company policy or direction. Why? The direction. She felt that somewhere in her teaching or training that it was okay to tell someone they couldn't come in based on a bag versus others that are walking in with the exact same or similar bags, which again is discriminatory and against public policy. Making Burlington's, because they are acting as their employer, even if they're outside security and they're working for someone, the employer, which is who they're working for, not who's on their chest, is liable for their actions. This is also why I talk about security guards. One, they're not police officers, and two, just because they work for Allied becomes a responsible party because it goes under the Managing Partners Act, as well as whatever company they are working for at that time also becomes liable for their actions. Now, I put in here potential tort liability. Why? Because this is not a demand letter. This is a formal notice that's legally binding. Under Texas law, a corporation may be held vicariously liable for the tortious acts of its employees when those acts occur within the scope of employment. Exactly what I'm talking about when I'm talking about these security guards. This is one of those actions. She was working as an employee of Burlington at the time. She participated in discriminatory actions, which makes Burlington's liable. Goodyear Tire v. and Rubber Company v. Mays, 2007. Here, Burlington is liable for the security guard's unlawful denial of access. And again, the importance of doing this is letting them know I'm not going to state court, but state court supports my actions. Now, the notice and reservation of rights, because again, this is a formal legal notice, not a demand letter. This letter constitutes formal notice that Burlington has been made aware of this discriminatory act. Why do you do that? Because again, publicly traded company, and you offer them an opportunity to correct the behavior of those people, and not at just that store, but all of their stores. Now, under the doctrine of respondent superior, Burlington is liable for the action of its employees, and under 42 U.S.C. 1981 and Section 2000A, you may be subject to both compensatory and punitive damages if this conduct reoccurs. See, again, a publicly traded company. There is an enormous liability that lies with someone who says things that are discriminatory, even if they don't understand that it is or isn't. Because these things, while, again, very simple, Didn't really affect me more than 2 minutes. It was literally taken care of in a couple of minutes. But again, the practice, the understanding of I can't tell you guys to do something if I'm not going to do it myself. Now, if a similar violation occurs again, I will pursue all available legal remedies in state and federal court, including but not limited to injunctive relief to bar Burlington from continuing discriminatory practices. Why is that important? Because I'm telling them in advance, not just this store, but all stores. Because I can bar it in just one or I can bar it in all of them. Because the injunctive relief offers me that type of power. Why? The respondent superiority clause. And it's in their own working. Why? Because they are a publicly traded company. I've always said that because, again, that makes a difference because you have, I'm going to get into the other stuff. They are also liable for compensatory damages for humiliation and emotional distress. Now, again, just spoke about it because it bothered me because I have to, if I'm going to tell you guys to do something, I also have to follow through with it. Punitive damage for willful violation of civil rights. The reason why it becomes punitive is because they've already been put on notice about this action. So if it happens again, they have now said, okay, we're going to hand you some money to shut you up. Now, attorney fees and costs are authorized by Noonan v. Piggy Park. Now, that will be a consulting fee in some cases because, again, attorney fees are consulting fees because they are assistants, not employers. Now, I concluded with, I trust Burlington will take immediate corrective measures, including retraining staff and security personnel on non-discriminatory customer access policies. Failure to address this issue adequately will result in legal escalation. I signed off on it and left my information because it's about the conversation and making sure it doesn't happen again. So whenever you're in these types of situations, don't ever think that you don't have an opportunity to correct this behavior. Because if you're literally just trying to shop and someone's doing some extra stuff, regardless, especially if it's wrong, let's go ahead and make sure it is done correctly and you continue on about your day. Now, again, I went full nuclear on this. It's there. The Equal Employment Opportunity Commission. Why? Because now, again, publicly traded company to establish a civil rights discrimination record. The reason I want to do that is to make sure that even if they want to kind of gloss over it, it's going to get to somebody that has decision-making power. Now, again, the Texas Attorney General, I sent it to the Civil Rights Division to open a consumer discretionary inquiry upon Texas statutes or under Texas statutes. The reason being is because they are a publicly traded company. Their base is in California, and they're operating in the state of Texas, and they're doing discriminatory practices. And it's just to set the record. That's it. Because I don't expect anything from the Texas Attorney General. Because one, Burlington brings in too much money for them. So it's just for the record. And sometimes moving pieces is just to occupy a space. Right? And that's all this is. I'm moving upon to a space. If it dies, it dies, but it's just to occupy air at that time. The City of El Paso Human Relations Office. Now, the reason why I did this is because they're operating in El Paso, And it's for, again, violation of local ordinances prohibiting discrimination in businesses. Don't expect anything from it, but I'm setting a record. I'm not just setting it with Burlington. I'm leaving breadcrumbs. I'm setting up my pawns right now. So if it happens again, one of the things I took down location. I paid attention to the basically the personnel, and I paid attention to the time. Why? So when they go back and look at the cameras, they can actually see, oh, he actually is telling the truth, because the cameras are showing when I walked in what happened, because I did everything literally in front of the camera. And most people don't know this, they have audio. And when I spoke to the manager in front of another camera with audio. So again, these are things that can be verified. And the Consumer Protective Division of the Federal Trade Commission for unfair business practices under federal law. Now, most people will be like, you did too much. And I agree. For what happened, this is extreme. However, I want to make sure that even if they don't want to address it properly, it's going to be addressed properly. And lastly, the Burlington's Board of Directors. This I actually went through my brokerage account, looked up Burlington, their ticker number or ticker symbol, and then send out letters. And I'm also sending out a certified letter to the CEO. The reason being is the paper trail. I'm gonna give it about a week before I go back in there, because I got my seaweed for right now. But again, understanding there's avenues to protect yourself and make sure where you're going, you're not. Because I don't go in there, I don't talk to anybody, I don't act a fool, I don't even ask questions most of the time. I just wander the store and go find what I'm looking for. Now, I don't expect no one to mistreat me, especially in a place like that. And again, did I go farther than necessary? Absolutely. But again, what I tell you guys to do, I can't keep, well, if you're part of the problem, you're either part of the problem or you're part of the solution. And then if you accept it, you're part of the problem. I can't be part of the problem and then tell you guys not to be. So I do the complaint. Do I plan on doing a lawsuit? No, not at all. So, but again, I'm making sure the behavior is corrected, and I'm also making sure that it's addressed immediately. Now, if it happens when I go back, then we're going to have a different video, because I'm going to show you how I lay out the lawsuit. Because I've already dropped the breadcrumbs, I've already sent out the notices, and here's the great part about it. Most time when you're suing big companies like this, the state requires a 6-month notice. By me going out and doing it now, they've already been put on notice. So my 6 months, once I get a response, or actually once I send out the letter, I have the timestamp that they have been put on notice. So I don't have to wait another 6 months for them to come up with some negotiating plea. No, I'm going to go ahead and hit them across the head, because I'm going to tap them pockets, because that's what they're asking me to do. So don't ever think that you don't have an option to be safe, be protected. And even if you're filing a complaint against something, there's a proper way to do it to get the result that you're looking for. Because again, this is not about money. This is about leave me the hell alone so I can go do what I want to do. I'm trying to give you money. Let me give you money. Now, again, it's one person, and it's never happened before. I don't expect it to happen again. It was addressed literally 120 seconds maximum. So but again, it's part of my mindset of, if I can't ask you to do something I'm not willing to do. So thank you guys for watching. I'm actually a little tired, but I took a nap earlier, so I might be back up in just a few minutes and dropping off one more for you. So let's keep going. Let's keep growing. And yeah, I'll probably see you guys in just a little bit.